A good case that illustrates a lot of the issues that we're going to be talking about over the course of the course is the case of Arkansas versus Rickey Rector. This was a case out of, and it's in the readings, out of Conway, which is in Faulkner County, Arkansas. Tragic death here of a police officer, Bob Martin, who had come to arrest Rickey Rector, who had shot and killed someone else just a short time before and had been on the run, but agreed to come back to his mother's house, and Bob Martin was a friend of the family, and he came to arrest him, and to everyone's complete shock and amazement, Rector walks up behind Martin and shoots him. But then what he does next is walk out in the backyard and put the gun to his own head and give himself basically a frontal lobotomy. A lot of people thought that Rector wouldn't live, but he did. And so then the question becomes, what do we do in this case? This is a community that had never before even had a police officer shot, let alone a police officer killed. And so there's a tremendous reaction in the community because Bob Martin had been a great public servant. He was loved by people there, and there was a feeling that the death penalty should be imposed because of this loss of a law enforcement official. This case is full of politics from the start to the very end, when Bill Clinton, running for president in 1992, comes back to preside over the execution of Rickey Rector right before the New Hampshire primary. In fact, Clinton had scheduled the execution by signing a death warrant so that Rector would be executed. But Rector, who had been a pretty troubled person and somewhat troubled mentally to begin with, was even more severely impaired after he shot himself through the front of his head. And we'll talk a little bit about how that was looked at in the case. But first, I just raised the question, what do you do if you're the district attorney there in Faulkner County? The police, of course, want the death penalty. We don't know what the Martin family wanted, but we assume the family may have wanted the death penalty. No question the community wants the death penalty. But we have a man now who is profoundly damaged as a result of this self-inflicted wound. Do we still seek the death penalty? If we do, what's our purpose? Is the purpose to show people, regardless of whatever the facts are about Rickey Rector, is the purpose to show people that if you come to Conway, Arkansas and kill one of our police officers, you're going to get the death penalty? Or is there other considerations that should take into account the individual circumstances of Rector? Would it be possible, as happened in the Jared Lochner case, the person who shot Gabrielle Giffords, the congressman, and killed a federal judge, as well as a little girl and other people, in that case was ultimately resolved with a plea disposition, where the families and the community and everybody agreed the best thing in this case is to make sure that Jared Lochner is never in the community again, but not to go through a death penalty trial and the appeals and so forth that would go with it. Well, that obviously wasn't the decision that was made in Faulkner County. But it's important to point out two decisions that the prosecutor had to make. First, whether to seek the death penalty at all. It's never required to seek the death penalty. No case is a mandatory death penalty case. And then second, even after the prosecutor had announced we're seeking the death penalty in this case, you could always offer a plea bargain, life imprisonment without any possibility of parole, resolve the case without a trial, and of course a different sentence. In this case, both those questions were answered, that the prosecutor was going to go forward with the prosecution. It was felt that they wanted the death penalty, even if Rickey Rector wasn't the same person. We want the death penalty for Rickey Rector because of what happened in the community and maybe for this deterrence purpose that I talked about. But you can see that that issue is not just a legal question. Is he eligible for the death penalty? It certainly is, because he shot a police officer and killed a police officer, but also a lot of political questions. And of course, the prosecutor's got to run for re-election in Faulkner County. So how much does that factor into the process? And then, of course, what happened in the case was, there's no question Rector committed the crime. Everyone knew that. So the question becomes, is he competent? Is he, as a result of this damage to his brain, is he mentally competent to stand trial? Now, we have the defense doctors who saw him, Dr. Brown, Dr. Stevens, psychologist, Mr. Heller, Dr. Heller, as well as his, Heller is his attorney in the Criswell case, the one that had tried before, and his sister, all describe how Rickey Rector is functioning. And we come out from that with a diagnosis that he has retrograde amnesia, he's damaged, he's brain damaged, he's got no emotion whatsoever. You go see him one day and he doesn't remember having talked to you the last time you went to see him. His intellectual functioning is tested at 66, later tested at 70, but basically this is a person who not only is thinking at sort of a childlike level, but is acting at a childlike level. Very childish in the way he behaves. The state doctors, on the other hand, Dr. Hamed is the main state doctor. He says Rector's lying about his loss of memory. That it doesn't have anything to do with this bullet wound through his brain. And he even says that by the second trial, he had improved. The state also had another psychiatrist and 2 psychologists. So you can see a lot of experts in this case. Unusual for a case involving a poor person to have this many experts, 2 on the defense side, and not unusual for the state to have 4 on its side. But where does that get us? They decided, the state doctors, that he was faking it and that he was not cooperating in answering their questions, and that his lack of emotion and his childlike behavior, they said, were life choices that he had made. So what do we do with these? These are the same diagnosis we had before. The defense experts come to the conclusion, manifestly incapable of assisting his lawyers in any way, that he's too childlike, too injured, too damaged to work with his lawyers. State, these doctors decide he could choose. Again, they're saying that he's faking it and all that. They're saying if he wants to cooperate with his lawyers, he can, and therefore there's no problem going forward with this. This is what the Arkansas Supreme Court will later say, that the evidence was hopelessly in conflict. These doctors reach one conclusion, one diagnosis, the state doctors, another diagnosis, another conclusion. How does this get resolved? One person. One person resolves it, and that's the trial judge. Of course, he too is elected by the voters there in Faulkner County. Whether or not that comes into play, we don't know, but we can't help but know that there's got to be some political pressure there with regard to it. Let's look at the legal issue that was presented by Rector's case. And what other issues are presented by his mental health. Was he competent to stand trial? Most fundamental question in this case, and this is what the case is all about. Because as I said, there's no question that he's guilty of the crime. Not much question that a jury in Faulkner County is going to sentence him to death, and he ends up with an all-white jury in a community that has about 10% African American. The statute is set out here, the Arkansas Code, which provides that a person who lacks the capacity to understand the proceedings, that is, understand what's going on, who the judge is, the prosecutor, the jurors, and how the proceedings are taking place, or assist his lawyer, that is, be able to have conversations with his lawyer, relate information, and that sort of thing, as a result of a mental disease or defect, is not to be tried if they lack this capacity. So those are the 2 questions we're asking. Can Rector understand the proceedings, and can he cooperate with his lawyers? Can he interact with his lawyers in a way that makes it possible for them to represent him? And as I said, the whole case is going to be decided on this one issue, and as I said, the judge is the person who's going to decide it. So the judge decides that he's competent, and then the importance of that finding by that one trial judge means that when the case goes to the Arkansas Supreme Court, it affirms, and it says the evidence is hopelessly in conflict, so we defer to the trial judge. The trial judge was the person who heard the evidence, saw the witnesses, and unless it's clearly erroneous, unless it's absolutely clear to us that he made a mistake with regard to finding of competence, we're going to defer to his findings. Every court, when the case is later reviewed in the federal courts, those findings are going to be binding on those courts So you see how the power of this one man, or really we see the power of two people here, the prosecutor seeking the death penalty, not plea bargaining the case, and then the power of the judge to decide the legal issue that's going to decide the whole case. If Rector had been found not to be competent, he would have been sent to a mental institution and he would have stayed there until he either became competent or it was determined that he just was not going to ever be competent. But of course, here he was found competent, which meant that the case moved on to trial. Let me just mention a couple of other issues raised by these mental issues often in cases. One is sanity. We've all heard of the insanity defense. Seldom really used successfully in cases, particularly by poor people who usually can't afford the expert witnesses and often can't get them from the court in order to even try to prove. But the difference here, when we talk about sanity, we're talking about the person's mental condition at the time of the crime. Whether or not the person had the capacity, again, the ability we're talking about, to conform his or her behavior to the requirements of the law and appreciate the criminality of what he or she did. In other words, the person who shoots someone because they think they're an enemy soldier who's invading the country, and they have a delusional belief, they believe this completely. I mean, that's sort of your classic example of an insanity defense. We don't have that in this case because, of course, Rector's damage to his brain and his functioning was a result of an injury he inflicted after he committed the crime. So no question about his sanity at the time he shot and killed Bob Martin. Mitigation, as we'll talk about later, is Rector's condition a reason for a sentence less than death? Do we take this into account? We look at the crime, the heinousness of the crime, the loss to the community, but do we also look at Rector's condition? And there's some argument about this, about, well, that wasn't his condition at the time of the crime, so we shouldn't consider it. And the other side, well, that is his condition now. This is the situation this man is in, profoundly damaged as a result of this gunshot wound. And so perhaps this is not a person who should be sentenced to death. The Arkansas Supreme Court, when presented with this question, said, well, this is a matter for executive clemency. Of course, at the time they said that, or for the governor to consider for executive clemency. Of course, at the time they considered that, they didn't know that clemency would come up at a time when the governor was running for president of the United States, and his law and order bona fides would be one of the most important issues in the case. As someone said, for Rickey Rector, that timing was very bad indeed. And then finally, at the end of the case, the question came up whether Rector was competent to be executed. As I mentioned just a little earlier, whether or not he understood why he was being executed. So those are, this case gives you a sense, again, of the way in which these issues come up in cases. Rector's case was not a celebrated case when it first came up in Conway, Arkansas, but of course it became a fairly well-known case at the very end because the role it played in Bill Clinton's campaign for President of the United States. And it certainly was seen by a lot of people as protecting Clinton from any attack that he was soft on crime, that he would not be like the previous Democratic nominee, Michael Dukakis, who had been opposed to the death penalty, and that cost him fairly dearly with the ads that were run against him when he ran for president. Well, let's go from that just to quickly talk about how these cases make their way through the system. Obviously, any criminal case is going to start with a crime being committed, and then an investigation which can last for as long as a few seconds if the offender is apprehended right there on the scene, or can last for months, years, however long it takes for law enforcement and the prosecutors to decide who it is that committed the crime. Once we know who committed the crime, then there's going to be an arrest. Again, that may be very soon, or you may have somebody who's fled the country or fled the jurisdiction, so that may take some period of time. Here's where we want to get into the legal proceedings that take place. Those things you're probably pretty familiar with. When you're arrested, you're entitled to a first appearance hearing. In other words, within a day or two of being arrested, a person should be brought before a judicial officer, a judge, or a magistrate. And the question here that's critically important, do you get a lawyer at that point? Because if you're accused of any crime, You want a lawyer at this point because if you're on a minor crime, you're hoping to get out on bail so you can go back to work, so you can keep your home, carry on your life in hope that maybe you won't ever go to prison on this case. If you're in a serious case, a death penalty case, you want your lawyer out investigating the case right from the start. Diego Marin, who was facing the death penalty in Del Rio, Texas, gets arrested, asks for a lawyer, 8 months. He goes for 8 months facing the death penalty with no lawyer. And you can imagine the damage that does to his case in terms of there's no investigation. He's not able to talk to a lawyer about his case, what's going on. He basically just sits in jail for 8 months. The prosecution is building its case, and he is not. At any rate, at this first hearing, a judge will usually tell the defendant what his or her rights are, set bail. Most capital cases, no bail is set in capital cases, but in other cases, the court will set bail, or in some cases, release people on their personal promise to come back. That is, their personal recognizance. Short time after that, in most jurisdictions, and this is, of course, we're generalizing here across all states, and so some of these things are not as true, maybe one place or another, but most places, within a short time after that, the defendant has a preliminary hearing, is represented by a lawyer. Of course, if you don't have a lawyer, like in the case I mentioned, for 8 months, you're probably not going to have a preliminary hearing because no lawyer is going to request a preliminary hearing for you. But at that hearing, the court determines, the judge determines whether there's probable cause, that is, whether it's probable that the person committed the crime, and if so, the person can continue to be held, either on bail or in prison. Most states still have grand juries, not all. In some states, the prosecutors can just file an accusation which sets out the charges. But in a lot of states, the case is presented to a grand jury. It considers the evidence and then returns an indictment. And the indictment is the formal charge. The fact that somebody's been indicted does not mean they committed a crime. It just means they're formally charged with a crime. Original purpose of the grand jury, or one of its purposes, had been that if you were accused of something you didn't do and the grand jury did not indict, you wouldn't go through the public embarrassment of being accused. Of course, today, that's really not the case. Grand juries are used to gather evidence and investigate cases, and generally everybody knows who's being investigated by the grand jury, at least in cases of any prominence. Once a person's indicted by the grand jury, they're brought before the court for arraignment. This is the proceeding where the person enters a plea of not guilty, or in some cases, this will be where the case is resolved with a guilty plea. Certainly in a lot of non-capital cases, a lot of people, a lot of poor people accused of crimes will meet their lawyer for the first time at arraignment, will plead guilty and be sentenced, all within about a 15-minute time period. Capital cases, generally a not guilty plea is going to be entered because nobody's going to plead guilty unless they want the death penalty. Most people are going to plead not guilty here. And then we go to pretrial hearings, which can be on all the issues that may be litigated pretrial, whether to change the venue in the case. Should we move it to another place where there's not the kind of knowledge of the case that there was in the Rector case? Is there suppression of evidence? The competency issue in the Rector case is a good example. This issue was not an issue tried to a jury. This was an issue that was decided in a pretrial hearing before the judge. There may be other issues like motions to suppress identification because it was suggestive, or some other motion to suppress a confession because the person was not a voluntary confession, or there was a violation of Miranda versus Arizona. Basically, any issue that's a legal issue that needs to be resolved can be litigated before, that is, a motion can be filed, and the parties can argue about it, present evidence on it, and the judge decides it before trial, before we get to the issue of guilt or innocence. Sometimes there'll be issues about what evidence is going to be admitted or not, and the judge will rule upon that prior to trial. Once that happens, we move to this process, the trial. This is where the trial is going to take place. This is where the accused is entitled to a lawyer under the Supreme Court's decision in Gideon versus Wainwright. And in death penalty cases, this will be a bifurcated trial. That is, two trials, one trial on guilt, one trial on penalty. After assuming the person is convicted, found guilty, in some states, like Alabama is a good example, there's an intermediate court of appeals. That is, there's the Alabama Court of Criminal Appeals, and then above it, the Alabama Supreme Court. All these cases go first to the Alabama Court of Criminal Appeals. It decides the case, and then a person can petition the Supreme Court to review the case, but it's not required to. Most states, the cases bypass the intermediate court. They go straight from the trial court to the state Supreme Court. Texas, for example, has a whole level of intermediate appellate courts, but the death penalty cases don't go there. They go straight from the trial court to the Texas Court of Criminal Appeals, or in Georgia, from the trial court to the Georgia Supreme Court. And then that state court makes a decision of whether reviews the trial, the briefs that are filed, to see was there any legal error made at the trial, either in those pretrial motions that we just talked about, or admitting evidence during the trial, jury instructions that were given, anything that may have been discussed or decided, not discussed, but decided at the trial court level, the state Supreme Court may review. A party can ask the United States Supreme Court to review it by filing a petition in the Supreme Court seeking review. Almost always, except in the rare case, that's going to be denied. So this is what we call direct appeal, directly from the trial court up through the state Supreme Court. Now, once that process is ended, person theoretically is eligible to be executed because they've had their trial and they've had their appeal. But all states provide some kind of collateral, what we call collateral attack on the conviction, or post-conviction review. And here the person can go back to the trial court and file a petition or a motion saying, my death sentence or my conviction was obtained in violation of the constitutional laws of the United States and this particular state. But one thing, the person cannot raise any issue here that could have been raised at trial or in the state Supreme Court. So what does that leave? If you've already raised these issues before trial or during trial, and you've raised them in the state Supreme Court, what's left? Generally, one issue heard here is a question of ineffective assistance of counsel. Obviously, a lawyer can't be claiming to be ineffective while representing someone. The lawyer's hopefully providing and thinks he or she is providing effective representation. So that question can be decided here. Suppression of exculpatory evidence. More often than we would like to see, we find that the prosecution has failed to disclose some important evidence to the defense. And as a result, the argument is that the trial has not been fair because the government has a duty to turn over evidence that tends to show the person is not guilty. So that issue could be raised there. Sometimes people learn of jury misconduct, that the jurors may have done something that they're not supposed to do. So that issue could be raised there. And that's not exclusive list, but that's an example. And then again, depending on the state, it will either go to the state intermediate court or it'll go to the state Supreme Court, and again the person can petition the United States Supreme Court for review. Again, very unlikely the Supreme Court is going to review it. Most of the time they're not, but if there's a really important legal issue there or an issue in which courts are divided, then the Supreme Court may take the case. Finally, the last resort for someone sentenced to death is to file a petition for a writ of habeas corpus in the United States District Court where they are. This basically is a petition that says, I, the death row inmate, suing the warden of the facility that's holding that person and being held here in violation of the Constitution of the United States. The fact that the state law issues, no longer. Those could be litigated in state court, but not in federal court. There has to be a federal constitutional violation. I am held in violation of the federal Constitution in that there was racial discrimination in my jury selection in violation of the 14th Amendment to the United States Constitution. That's a classic example of a claim that might be made in the United States District Court. That court decides the case. let's say it rules adversely to the death row inmate, the person can then first ask the district court to allow him or her to appeal to the Court of Appeals. They're not entitled to an appeal. The district court can either say yes or no, this issue is important enough that it can be appealed. Or if the district court says no, the person can go to the Court of Appeals and make the argument a second time that this is an important issue. But very often that court will say no. And so that's going to pretty much, and then of course the person will petition the United States Supreme Court for review, but failing that, that person is probably going to be executed, and probably executed pretty soon. Texas has executed far more people than any other state, and one of the reasons, there are a lot of reasons, but one is that once these cases come to federal district court, they're usually denied. A certificate of appealability to the Court of Appeals is denied. So once this court rules, there's nothing left between that person and the execution chamber. So habeas corpus used to be a way in which a number of capital cases were reviewed and sometimes set aside. The difference, life tenure judges. These judges are appointed by the president, confirmed by the Senate. They serve for life. Not to say there's not some politics both in getting appointed, and not to say that there are not some federal judges who are ambitious to go on to other places, but at the same time there's a lot more independence when you have life tenure. A judge in the state court who makes a decision, either a trial judge or an appellate judge, may be signing his or her political death warrant if they grant relief in a death penalty case. Not so for a federal judge. And at one time, the federal courts were pretty vigorous in enforcing the Constitution. Congress passed and President Clinton signed into law an act which we'll talk about, which greatly restricts the power now of the federal courts to review these cases. So that gives you an overview of just when we're talking about these cases, you'll have some sense of where they are. We'll look at cases decided by state Supreme Courts. We'll look at cases decided by federal courts of appeals, so you'll know how they got there. And of course, we'll look at a lot of United States Supreme Court opinions. So I hope this gives you some sense of where we are in the process as we look at those cases. And we'll also look at examples from trial courts as well, including some transcripts of jury selection and so forth. So that's the roadmap of where we're going. And we'll next take up the historical sort of backdrop leading to where we are today with the death penalty in the United States.